Hi, I'm Brice Zoecklein. Today we're going to talk about some basic estate planning. First of all, what is an estate plan? Well, in general terms, it's a way to deal with your assets when you pass away and a designation of who's going to accomplish the transfer of those assets. There's a few popular things that work for most estates, but remember, a plan for you needs to be tailored about what you want to do. But here are the main tools that work in Florida. Number one, a last will and testament. This is a document that most people have heard of. It controls the distribution of your stuff after your death. In Florida, it's got to be signed by the testator, which just means the person making the document, along with two witnesses. It's further signed with an affidavit called a self-proving affidavit that makes it easier to get admitted to court. A last will and testament, if done correctly, needs to be flexible, okay? You don't want to move to change your will just because you acquired or lost an asset. That's why we always recommend in a last will and testament that we allocate a percentage of distribution and not specific assets. But generally, know that it allows you to designate where your assets go and who should be in charge of seeing it through. That person in Florida is called the personal representative. Once you sign your last will and testament, the court's going to need the original if you pass away. So put that in a safe place like a safe or a safety deposit box, and the designated personal representative or executor needs to know that they're designated and give them a copy so that they know that they're in charge of your estate. That document, when you pass away, gets deposited with the clerk of court. To the extent that you died with assets subject to the probate process, a probate proceeding will be necessary with the last will and testament. The second powerful tool or common tool used in Florida is a power of attorney. And that is a document where the principal, the person giving the power away, gives the power to an agent to take action on their behalf. Why do you need that? Well, a lot of times people, as they age, lose the ability and they take for granted the ability to pay the bills and manage their financial affairs. A power of attorney is a great tool to let a child or other loved one or trusted person help you deal with the normal infirmities of aging by assisting you in managing financial affairs. The third category of things is really two things, and that's a healthcare proxy or a living will. But both of those things just identify now, while you have the competency to do so, what you would want to happen if you're not able to articulate your desires as to medical care. A living will specifically states those out, and a healthcare proxy alternatively just leaves that to a particular person to make that decision should you be unable to articulate what you want. The other major tool in estate planning is a revocable trust. A revocable trust is most easily thought of as a separate entity, and we always tell our clients, think of it as a box that has its own rules and regulations, and we'll write a trust agreement that is like an operating agreement for a separate business. The trust has three basic parts. Number one, it contains a grantor or a settlor who puts assets into a trust, a trustee who's obligated to manage those assets, and a beneficiary who simply receives the assets. When you start a revocable living trust, typically the grantor, the trustee, and the beneficiary are all the same person. But after the death of the grantor or grantors, if there's two people, a surviving trustee steps in to manage the assets based on the preset rules of the trust. So, for example, the successor trustee distributes the assets under the terms of the trust agreement for the benefit of the beneficiaries. That can also have a number of preset conditions, so the distributions don't occur unless and until, for example, someone graduates from college or they reach a certain age. It makes most sense to understand a trust by comparing that to what can be accomplished with a will and with a trust. Remember, a will allows for a specific automatic distribution to beneficiaries upon death, where a trust can restrict the flow of capital. That's called the hand beyond the grave. Revocable trusts are then powerful tools if you have a blended family to ensure that beneficiaries receive assets, and also a powerful tool if you want to incentivize your beneficiaries in the future by graduating college or not getting a lot of money until they reach a certain age. Ultimately, a will is ideal if you have a straightforward estate, adult beneficiaries, and you want a simple, straightforward distribution after your death. A trust may make more sense if you need to restrict the flow of that capital in any way. Ultimately, modern estate planning seeks to avoid the necessity of probate, which can be accomplished easily through bank accounts by naming a beneficiary or changes to property to make automatic succession occur. When considering what's the best estate plan, you should think about, well, who's going to be in charge of the estate and what can I do to make their life easier, aka what can I do to avoid probate if possible. Ultimately, whatever estate plan you choose should be geared to your specific situation. If you have questions or you'd like to develop an estate, we have tons of resources on our website, or just give us a call. We offer free, no obligation consultations.